All right, good afternoon, everybody, and welcome to today's MSHA Defense Report webinar series, webinar on MSHA and OSHA jurisdiction, when, how, and why to challenge your regulator. We are going to take some time today to look at the distinctions between OSHA and MSHA and which regulator has authority over which work sites. Also, what is the process for challenging that if we get to the point where we think we're under the wrong regulator, or we are starting a new operation and we're trying to determine what regulator we should be under or will be under. So we're going to take some time today to review that. We will look at a number of different aspects, some case law, some of the legal background documents, and then some practical applications. But for those of you who are new, welcome. My name is Nick Scala. I am the chair of the National MSHA Practice Group at Cranesville. We're a boutique firm that handle and support employers nationwide with occupational and mine safety and health matters, so workplace safety and health, as well as labor and employment. Particularly, I spend my time working with companies involving discussions with MSHA and OSHA, whether that be interacting during enforcement activities or investigation management, or discrimination proceedings and whistleblower proceedings, or challenging the jurisdiction of the agencies and who is over what operation, and helping counsel clients through that process, and if possible or if necessary, working with them to reassign the site or determine which is the proper site. So first and foremost, what are we going to look at today? We're going to review the controlling document here, the one that we always come back to. There's the Mine Act and the OSHA Act. Obviously, those are the legal documents and the statutes that created both of the agencies, but there is an interagency agreement between MSHA and OSHA, and a memorandum of understanding, it's also called, which outlines which agency has jurisdiction over what work sites. And it's really the beginning point. And if we're going to be looking at jurisdiction and which regulator has jurisdiction over our work site, that's the best place to start. It's going to give us our foundation. From there, obviously, it's been argued in front of the courts, whether the Occupational Safety and Health Review Commission or the Mine Safety and Health Review Commission, and then up into the federal circuit. And we'll take a look at a couple big cases that have been shaping things in the last few years. But that interagency agreement is really our starting point in any discussion regarding the jurisdiction and the assertion of jurisdiction by one agency over a work site. We'll also talk a good bit about the mining versus the manufacturing process, because a big question is going to be who covers the mining process and who covers the manufacturing process. And it's not necessarily as black and white as saying OSHA is over manufacturing and MSHA is over mining, because there's other factors that have to be considered. How similar are the operations? What kind of products are being used in the operations? Are they co-located in the same property on distinct properties? So we'll review that, as well as when does MSHA jurisdiction begin at a mine site, if we're starting on a green field and beginning a mine, or if maybe we're bringing another mine back in or expanding the operations on an existing mine. And then lastly, we'll talk a bit about challenging your jurisdiction, right? So what if we come to the determination after all this discussion, all this analysis, that we really think we have the wrong regulator? How do we go forward? And what are our options to do that before enforcement and after enforcement? So that's a overview and a roadmap for what we're going to be looking at as we go through today. As always, feel free to type your questions in the chat if you have any as we go, and we'll get to them either during the presentation or at the end. And I look forward to an interesting discussion with you all. So as I said a few moments ago, this all starts with the interagency agreement. That's kind of our foundational document when we're talking about OSHA and MSHA and who has jurisdiction over what. This is a document that was signed and accepted by the agencies back in 1979, so shortly after the creation of MSHA, and it is meant to give that initial delineation between where OSHA is a regulator and where MSHA is a regulator. It is going to set forth factors regarding determinations, and it's going to look at what is the convenience of the administration, meaning is one regulator a lot closer or a lot more or a lot better situated to enforce and regulate a particular work site. It's going to look at determining the jurisdictional questions and coordination between the areas where MSHA and OSHA might have a mutual interest in regulation. So it's really, though, it's just that document that sets out the basics for who has jurisdiction over what. And particularly, we see in that a couple quotes highlighted very early and often when we're talking about the assertion or the establishment of MSHA jurisdiction, where we quote the Mine Act. And this is included in the Interagency Agreement. So really supporting where the Mine Act is going to claim and carve out its operation. So it says the Mine Act gives MSHA jurisdiction over each coal or other mine and each operator of such mine. And it defines operator as independent contractors. It includes independent contractors performing construction at mines. So already one of those areas where we're looking at construction, typically an OSHA regulated area. OSHA has an entire section of the CFR dedicated to the construction industry. If it's taking place on a mine, that very well could fall under MSHA's jurisdiction and MSHA's regulations and MSHA's training requirements. So it's important, especially as we're talking about expanding operations or starting a new mine, that we understand that our contractors understand that, because they are likely to be regulated by MSHA rather than OSHA. And likewise, if they're found to be non-compliant with MSHA but in compliance with OSHA, that doesn't necessarily mean that they're compliant, because again, it comes back to who has jurisdiction over that physical location. It also explains in quote section of the Mine Act 3H1 that just says MSHA jurisdiction is over land, structures, facilities, equipment, and other property used in, to be used in, or resulting from the mineral extraction, or to be used in as part of mineral milling. And then again, it again calls out what we're looking at here. It includes authority to regulate construction of facilities, structures, or other property on a mine site. You know, we also get more specifics when reading this document. It tells us some, not only just kind of the gray area and quoting the Mine Act, but it breaks it down specifically what operations are under MSHA and what operations are under OSHA. And now, you know, this is even beyond what we're going to talk about later, because we are going to review what is mineral milling, because that's a term that we come across a number of times in the Interagency Agreement. And, you know, where mineral milling is taking place, that should fall under the MSHA jurisdiction. But likewise, we actually get lists, right? And in these situations, it's pretty black and white who has jurisdiction over what facilities. So we can see here, and this is straight from the Interagency Agreement, that MSHA jurisdiction, it says, includes salt processing facilities on a mine, electrolytic plants where the plants are an integral part of the milling operation, stone cutting and stone sawing operations on mine property where the operations do not occur in a stone polishing or finishing plant. So again, a distinction there. If we had a stone polishing or finishing plant on mine property, that should be the jurisdiction of OSHA according to that statement. So an area where, again, we're looking at what is taking place and where is it taking place. And then alumina and cement plants. Those are going to be specifically called out for the jurisdiction of MSHA. Likewise, OSHA is going to get jurisdiction whether or not these facilities are located on a mine, with brick and clay refractory plants, ceramics, fertilizer, concrete, and asphalt batch plants. Those are probably some of the most common ones. It's obviously very common to go onto a mine and you might see a concrete plant or an asphalt batch plant. MSHA should not touch those. Likewise, when OSHA comes on site, if they ever come on site to investigate those facilities, they should not be investigating or inspecting the mining operations on site. We have specific delineations between the two on those areas, and that's because they're called out in this interagency agreement. It goes on to even say further that OSHA jurisdiction also includes salt and cement terminals not located on mine site. That would mean that salt and cement terminals on a mine site are regulated by MSHA, and milling operations associated with gypsum board plants not located on a mine. Again, so if there was milling operation for gypsum board plants located on a mine property, MSHA would claim jurisdiction to that. And so those are a couple areas. It looks like we have a question coming in, and it is asking about the interagency agreement. And it says if OSHA issues an ETS, which they have already issued one on healthcare specific, but we're expecting after President Biden's press conference last week that there will be one coming out for all industries under OSHA. Will MSHA be required to follow, or will MSHA adopt its own ETS? Do mines have to follow the ETS? So that is, those are good questions. When we're talking about this interagency agreement, there is delineation between the two. So with that, though, there is a clause in the interagency agreement that says if MSHA doesn't necessarily have a regulation in place which covers a specific safety and health hazard, it can be regulated by OSHA. Now, that being said, that's a very rare occurrence. It has not been exercised previously. MSHA has guidance in place for COVID in the nation's mines. They have, on numerous occasions, stated that as an agency, they believe guidance is sufficient for MSHA. That being said, they have also stated as an agency that they do have an ETS drafted. This is a situation where we might see MSHA issue their own ETS. So the long story, or I guess the short answer there is, if OSHA issues an ETS, it does not necessarily apply to the mine sites unless MSHA either adopts it or brings it in as a regulation that they do not have and they're going to adopt OSHA. I would expect before MSHA tried to enforce an OSHA regulation on its sites that they would issue their own ETS. But as we've seen throughout the COVID pandemic, MSHA is going to be on a wait and see. So I think with the agency, it wouldn't surprise me to see them wait, review what happens with OSHA, see what OSHA's final ETS for all other industries actually looks like regarding the vaccine or weekly testing requirements, et cetera, and then issue their own ETS is my guess. But that, again, could be a couple months down the line. In the interim, MSHA's guidance, it remains what it has been for the past few months. Their last guidance they issued was in March of 2021. It's pretty standard guidance, which reflects what we've seen from OSHA. It recommends that each mine site have a COVID protection program, that it is in place and people are trained to it. It lists out specific requirements in that. It also, recommends that CDC and other guidance is followed as that, including OSHA's, as that becomes available. And so, really MSHA has not taken an active role in trying to enforce this in the workplace. There have been some OSHA or MSHA enforcement on COVID, but it's been few and far between. They, in their guidance, particularly, or lay out standards which may apply to a COVID outbreak or a COVID exposure situation, but it's a lot less detailed and they have a lot less options in terms of enforcement. So I guess that's to say the ETS for OSHA would not apply to the mines unless MSHA adopts it. I expect if we see an ETS for all industries, MSHA could very well file their own ETS afterwards, and that would apply. It doesn't necessarily require that whatever OSHA puts out there that would apply at the mine sites. So we talked about, we also, getting back to the distinction between the different operations, we've talked about milling quite a bit. And milling is obviously a term of art that this interagency agreement focuses on a great deal. So milling is the process of what MSHA defines, or the agency, the art of treating the crude crust of the earth to produce therefrom the primary consumer derivatives. So what does that actually mean? It means that you're doing some kind of processing to the mineral, right? You are crushing it, grinding it, pulverizing, sizing, concentrating, washing, drying. These are all examples that MSHA lays out in the Interagency Agreement as elements or instances of milling. And milling is supposed to then apply to the mining industry and be under the jurisdiction of MSHA. So it doesn't need to be all of these. It can be one, or it can be a couple of them. We'll see a couple instances where that's kind of laid out in some cases, but most commonly we see sizing and separating by size, crushing and washing. Those are most likely the ones that are going to bring you in and are most prevalent at most mine operations. Now, that's not to say they're at every operation. I understand that, but typically when there's questions about whether or not a facility is actually doing milling, one of those very low level milling alternatives gets them into that situation, or at least is where we start. So are they crushing material? Are they taking out material in one form and they're crushing it down and they're washing it? Or are they sizing it and then separating it into stockpiles so they can sell bigger material to this customer and smaller material to the other customer? That alone would be an instance of milling. So it's certainly an area that we look at. It's supposed to be one that is distinctly going to give jurisdiction to MSHA. But then, of course, because the agencies always want to have a bit of wiggle room, they go on to further say the scope of the term milling may be expanded to apply to mineral product manufacturing, where these processes are related to either technologically or geographically to milling. So, one area where we're going to see a case on this very shortly is what happens with bagging facilities or drying facilities on a mine site. That is an area where it could certainly be seen as a continuation of the milling and therefore a continuation of the mining process or the beginning of the manufacturing process. And unfortunately, we see there's a number of instances, and one case in particular from the last few years, where the Department of Labor it talks a bit out of both sides of their mouth. So, it says that the determinations shall be made by agreements between MSHA and OSHA. That comes back to, if we are challenging it, we need to get the agreement of one agency to transfer to the other side. So there is some communication there. We can't just say, hey, MSHA, you don't have jurisdiction because of reasons A, B, and C. And they say, okay, well, we'll just let this one happen. Maybe OSHA will get it. There has to be some kind of agreement and transfer there. Additionally, if we're looking at whether something is milling versus manufacturing, and again, maybe a continuation of that milling process, it is going to look at are the processes completed at the same facility. Again, we already saw that was a distinction where, we might have gypsum processing or board plant processing. If it's on a mine site, it's under MSHA, where if it's off a mine site, it's under OSHA, or the salt terminals or the cement terminals. So that's an area where, are you conducting operations at the same facility? That might be the distinguishing factor that decides your jurisdiction. Now, that being said, if you mine material at a pit and put it in a truck and transport it 5 miles down the road to crush it, screen it, and mill it and process it, that's a continuation of the mining process, and MSHA would have jurisdiction over both facilities. So leaving the facility doesn't necessarily mean that you are going to have a change in your jurisdiction. It can follow, but it depends on what processes are taking place. How related are the processes to each other? Do you have common equipment? Do you have common processes, or do you have common employees working? Are they in the same facility? Are they in different facility? Again, none of these are black and white, but they are all part of the analysis if you're trying to evaluate if something is under the milling or under the manufacturing process. And then lastly, they're going to look at, does one agency have more familiarity with the processes or more expertise in the processes that the other does not? So a good example here would be refining. Refining can be part of the milling process when you continue to manipulate an ore. But typically that's a line where it goes to OSHA because OSHA may have more experience in the processes that go into refining a material as opposed to MSHA. Likewise, if whatever process you're doing on the manufacturing side is incredibly similar to the mineral milling or the mining side and the processing side there, MSHA may retain jurisdiction. So it depends. There has to be a look at what each operation or each process is completing. So again, MSHA usually has jurisdiction over anything that is mineral milling, but not always, because it's going to look at what kind of material is being used, what is taking place, is it getting blended with other material. Those are all questions that we want to ask. And OSHA usually has jurisdiction over what is considered manufacturing, but what's considered manufacturing at one side might not always be what is manufacturing in another, depending on these other factors. So do we have a change in the processes or the facilities? Again, are we doing it with the same employees and equipment, or is it different? Are we having different corporate entities? Maybe there's the mining entity versus the manufacturing entity. It's, again, not going to be a deciding factor necessarily, but it is a factor that plays out. One that consistently comes into play, if we're trying to distinguish between the mining and the manufacturing process, is what material we're using. And if the material is in a state that it can be a final product sold to end users. So one case, and this is from the end of 2017, and it was a Second Circuit case. And so this was actually an OSHA docket. And it was at a company that was historically regulated by MSHA. And on site, they had a bagging facility. So they mined the material, they processed the material, and then they dried and bagged material. And the question came in because there was a complaint investigation. So OSHA went out because the complaint was made to OSHA, and they issued a bunch of citations in this bagging plant. The company contested them, saying that this is an OSHA regulated facility. We're involved in mineral milling because we're continuing the mining process. So the question was, where did the mining process end and the mineral or the manufacturing process begin? And so the distinction here was, what state was the material when it started being bagged? And an essential part of the analysis from the Second Circuit was that they were beginning to use, or they were using, a final product from the mine. And that's because the mine had extracted the product, it had milled it, it had crushed it, washed it, dried, sized it to a specification, and then stockpiled it. That material that was stockpiled was sold to end users in that consistency, in that variety or derivation of the ore, but it was also then put into the bagging plant, where it was further dried, mixed with other materials, and put into bags. So typically, it's on the same mine, it's on the same site, it has historically been part of the MSHA jurisdiction, but in this case, OSHA determined that they wanted to claim jurisdiction over this bagging facility and that it was part of the manufacturing process. So an interesting take by the agency, trying to take away what has historically been MSHA jurisdiction for OSHA. So, you know, that's one of the ones when I was saying the Department of Labor was a bit talking about both sides of their mouth. So in this instance, the company appealed the fines and the ALJ vacated it because it said that this was part of the mining process and a continuation of the mining process, and therefore MSHA had jurisdiction. Likewise, the Occupational Safety and Health Review Commission, split decision. They could not come to an agreement there, and so the judge's decision was finalized, and it was appealed to the Second Circuit by OSHA. There, OSHA made the argument that the manufacturing process had begun because you had a product that was ready for sale and was sold to end users, being that material that had been processed and stockpiled. They said that that was the distinct end of the mining process, and anything after it was milling. The Second Circuit deferred to them and gave OSHA the ability to claim that as their own. And in doing so, they created now kind of this OSHA bubble in the middle of a mining facility. So it's a mine, you have the mine processing plant, you have the mine stockpiles, and then in this building, there's actually a division between MSHA and OSHA, where there is a maintenance shop that is still under MSHA jurisdiction in that building, but the drying and bagging operations are under OSHA's. So again, it was looking though very closely and focused a great deal on the end product being ready for use by others. And in this case, OSHA said that was the dividing line because it no longer needed processed in order to be made usable by those other than the drying house or the bag house. So an interesting decision where we saw kind of the agency apply that to get what was previously a mining operation under OSHA. Likewise, you can see the arguments made the other way. And that's really what the company was in the position of doing at that point, saying that we were continuing the mining process because we had this material, but it needed to be further altered in order to be ready for sale. And that was going to be drying it and bagging it. So an interesting area where there's a division between the two agencies within the Department of Labor about what is the beginning of the mining process and what is not. I can tell you that I work with a number of different operations around the country that have drying as part of the milling, and MSHA typically claims jurisdiction over that. The question here is the bagging and whether or not that material that you put into the bag house can be sold and used in that form. That was really kind of the area where that occurred and why that became an interesting case. Next, an area that we come across that is specifically called out in the Interagency Agreement is the assignment of jurisdiction over borrow pits. And these come up quite a bit because they're one of the few areas that would very much seem to be a mine where OSHA retains jurisdiction over them. And when we're looking at borrow pits, we're looking at areas where we're not really engaging in the milling of material. What it says, this is a definition from the Interagency Agreement that they give. I'm not going to read all of it, but I broke out and I bolded part in the middle. And typically when you're going to be in borrow pit, you're going to satisfy these criteria, and that is extraction occurs on a one-time only basis or intermittently as need occurs for use as fill materials by the extracting party in the form in which it's extracted. No milling is involved except for the use of a scalping screen to remove large rocks, wood, or trash. So what is a borrow pit? It is meant to be an area where material is taken out and used in that form. It is used as fill material on construction products or other types of use where it does not necessarily have to be manipulated. You don't dry it, you don't crush it, you're not separating it by size. You can screen out debris and material or impurities, but just by use of a scalping screen. So it's a very basic kind of operation, but nonetheless, it's looked at as being under OSHA's jurisdiction, not MSHA's. Now, I will say though, the bounds of what is a borrow pit continue to be challenged. There's questions about where does the mining process begin? What if you're drilling and blasting, but again, you're not processing material, but you have hard rock? Well, there's a case about that a few years back where a mine challenged whether or not it was going to be under MSHA's jurisdiction. And because it was involved in drilling and blasting, that was found to be part of more so mining, even though the material was being used for a construction project and the material was being used as a fill material. You know, other instances, though, I've worked with companies down in the southeastern United States where we have convinced them to relinquish jurisdiction of facilities, and they are continuously operating, but they have no processing. They load material from an excavator into dump trucks and it's taken off site. Is it used just for fill? No, it's used in the main mining and manufacturing process at other locations. But because there is no processing taking place, in that case, MSHA relinquished jurisdiction. Now, is that going to happen every time? No, because there is a lot of subjectiveness here. And there's a lot of, well, we'll just call it lack of consistency, where the agency gives deference to its each individual offices. So if you are in a situation where you think maybe you should be under MSHA jurisdiction or you should not be under MSHA jurisdiction, which is more likely the case, and you want to challenge that, you obviously, you challenge that with the field office, you challenge that with the district most likely, but you don't have to stop there. You can keep going. And that's even before you get into the litigation side. So borrow pits, they're not very common. They're a lot of times they're used with construction projects and they mirror them. This should not be part of or under the jurisdiction of MSHA unless you're crushing and sizing material. If you are in a construction project and you're taking material out from nearby to use it as fill, but you're putting it through a portable crusher and you're sizing it and you're blending it, that's going to be under MSHA's jurisdiction. So that's an area where you need to be sure what you're doing. If you think that you're just crushing material so that you can be used in your project, that doesn't necessarily mean that you are going to be under OSHA, because you are crushing, you are sizing, and that's an area where MSHA is going to get involved. It doesn't matter if you're selling it. If you're selling it, you're probably going to most likely come into the situation of being a mine rather than you're using it just for your own purposes. But these are a sliding scale. It's not one is determinative over the other. Another area that this kind of comes in is a case, and it was one where there's a facility, and this was up in New York, and they had a stockyard. And so they bought material that was already processed for the most part from mines, and then they just sold it to other companies in the area. They did not extract any material, but when it came on site, they put it through a portable plant to resize and to break it out into different size material and stockpiles for sale. So MSHA claimed jurisdiction over the facility. The facility argued, hey, there's all kinds of other operations and stockyards around that do the same thing. They're under OSHA. We're not extracting it, we're not crushing it, but they did separate it by size. That was a situation where MSHA claimed jurisdiction and it wasn't affirmed. So you need to look at what you're doing, because something as something as basic as sizing material can bring you under the mineral milling. So again, this is, an argument that we see a lot. Hey, there's other mines around here that don't get regulated by MSHA, why not? Or there's other operations that are getting regulated by OSHA, why we're getting regulated by MSHA. That's not necessarily persuasive alone. It can certainly be a good argument, but you need to align and make sure that what you're arguing with the agency, first, does not fall under mineral milling if you're challenging MSHA's assertion, but two, that your facility definitely aligns with the practices at the others. But that was one question where, consistency definitely comes into play. And that's a question and a challenge throughout all jurisdiction arguments, whether you're arguing whether or not something's a borrow pit or it's the mineral milling process versus the manufacturing process, et cetera. Also, it makes clear that extraction is not required on site. And we talked about that in the very beginning when I said, if you take material from point A, transfer it to point B, but then start doing crushing and sizing, both of those are going to be under MSHA. Both of those are part of the mining process. It does not necessarily mean that extraction has to take place on site. Mineral milling can take place off-site. It can take place separate from the extraction process and still be regulated by the Mine Act. So, another area where jurisdiction comes into play, and oftentimes this is the area where enforcement comes into play if we have a situation where we are not complying with Mine Act requirements. So it comes down to the training. Most often, if we have a company that, somehow MSHA shows up on site and they think they're under OSHA jurisdiction, so they haven't been paying attention to MSHA compliance requirements. They're not even trying to intentionally skirt any regulation. It's just an honest mistake. Where we typically see the enforcement happen immediately is training of the workforce, because those individuals may or may not need minor training. It also comes up when we're a new mine. So when do we start becoming a mine? Who has to have what training on site? Those are questions where we also see the jurisdiction analysis have to be applied, and where we see companies who, might just assume, well, hey, we're not a mine until we start producing material. That's not necessarily the case. You were likely a mine long before that day ever came that you put through your first bucket of material. And you were obligated at that point that you became a mine to comply with MSHA requirements and MSHA training requirements and other MSHA compliance obligations. So the section, again, 104 of the Mine Act, we already looked at these, so we'll go quickly, but how does MSHA define operator? It's those persons or entities that are going to be producing material, extracting material, running a mining operation, but it also includes independent contractors performing construction at mine sites. And then lastly, in section 3.8, again, where does MSHA jurisdiction land? It's over all these different facilities, all these different structures that are used or to be used is a key term here, in the mining process. And they have the authority to regulate the construction of such facilities, structures, or other property. So, where do we see this in terms of application on the site? A lot of times it comes down to the question of tree clearing and site prep. At that point, are you part of the mining process? At that point, are you a mine? Are you under the jurisdiction of MSHA? I will tell you, MSHA's position is, for the most part, yes. Now, MSHA, for the most part, they consider tree clearing and site prep to prepare for a mine or to expand an existing mine part of the mining process. That means if those persons performing that work are on site for a frequent or extended period of time, they are going to be miners. They need to have miner training. They need to be complying with workplace exams. They need to be complying with pre-shift mobile equipment inspections. That is definitely an area where we see a lot of confusion. Now, if we're on a site and it's a mine site and someone is just clearing trees because they're going to clear trees and sell them and they're not part of the mining process, that does not necessarily become part of the mining process. And that individual does not necessarily become a miner, even if they're on site for frequent or extended periods of time. They would only need to have site-specific hazard awareness training. And MSHA, has gone as far to have a Q&A page about tree clearing where they go into some greater detail on this. And they also put up a program information bulletin a while back, and this is back in 2004, but I'm sorry, 2011, but it looks at specifically the question. So contractors that cut trees as a mine service and work for frequent or extended periods of time are subject to comprehensive training under Part 48 or under Part 46. So that right there tells you that MSHA considers that part of the mining process. If miners are performing work that might be logging, MSHA says that you need to make sure that they have new task training. They have to have up-to-date miner training. They have to have up-to-date annual refresher. And so you need to make sure that you're looking at that. And this specifically is going to be, are you clearing trees to build a new mine, or are you clearing trees because you're going to move your extraction area to a different spot on the property. If that is the case, those individuals are under the mining process, and MSHA's made that pretty clear. So, you know, it is a question where site prep is going to be the same way. If we're talking about earth moving, clearing overburden, if we're prepping an area, if it's part of and to be mined, MSHA is going to consider that under their jurisdiction. So additionally, if we're looking at miners and non-miners, you know, that's going to determine whether or not someone has to have comprehensive miner training or someone just has to have their site-specific hazard awareness training. MSHA, for the purpose of Part 46, says that any person, including any operator or supervisor who works at a mine or is engaged in mining operations, including independent contractors and employees of independent contractors engaged in mining operations, are miners. Okay, so what are mining operations? Well, they luckily lay that out for us too. It's mine development, drilling, blasting, extraction, milling, crushing, screening, sizing, and maintenance of repair of equipment. One area that kind of gets people in a bind sometimes with jurisdiction is the over-the-road truckers or commercial truckers. If they are coming on site, picking up material and leaving your site to go deliver it somewhere, those individuals are not miners. They will need site-specific hazard awareness training, but they are not miners. But if you take that truck driver and you tell them to pick material up at point A on the mine site and take it to point B on the mine site, they become miners, because that is the associated haulage of material within the mine. So that's an area where, you know, on frequent occasions I've helped and worked with companies where they're getting 104G orders and withdrawal of truck drivers because they don't have comprehensive miner training, and they want to know why. They're over-the-road truck drivers. It's because in these situations, the trucker was taking something from point A to point B on the mine. Maybe they were just moving a stockpile. But if that happens and you're using commercial truckers for this, they automatically become miners. So that is a distinction you need to look at. Additionally, under Part 46, it says that any construction worker who's exposed to hazards of mining operations is going to be considered a miner. So that is a definition that, you know, is going to apply to a lot. So mining hazards and mining operations. So again, mining operations means mine development. That's going to be site prep. That's going to be construction of a facility. It's also going to be those persons building facilities. So they can certainly fall under that definition. It's just, as I mentioned before, it doesn't include scientific workers, customers, deliveries, or those over-the-road truckers, unless they are going to be working within the bounds of the mine for all of it. You've heard us say the term frequent or extended period of times on a number of different occasions, because that is a definition that, or a term under Part 46, which will help determine whether or not someone is required to have comprehensive miner training. So, and it particularly, it's going to apply to maintenance or service workers who aren't going to be on the mine for extended periods of time. So if you're engaged in mining operations, you are going to be a miner, even if it's an independent contractor. If you're a service worker, and that could be an electrician, that could be, you know, a plumber, it could be a mechanic for equipment who comes on site intermittently. If those individuals are on site for frequent or extended periods of time, they are going to satisfy the definition of a miner and need to have miner training. And we see similar language in Part 48, where it says that any person working on an underground mine is a miner, or who's engaged in the extraction production process, or is engaged in shaft and slope construction, or regularly exposed to mine hazards, or a maintenance and service worker employed by the operator, and is there for frequent or extended periods. So regularly exposed, frequent or extended. They're both used by Part 48 and Part 46 in helping to determine who needs to have comprehensive minor training and who might be able to satisfy just site-specific training, but continue to rely on OSHA training. So it's something that we need to look at. Here, MSHA defines frequent as a pattern of exposure to hazards at mining operations occurring intermittently or repeatedly over time. That's not really that helpful to us, but contractors should be looking at this. And if they have someone going to a mine site frequently, maybe it's every other week or every other month or every month, that person is probably going to have frequent exposure to mining hazards. They say that extended is exposure of more than 5 consecutive days. You know, it really depends on how that's going to apply. So there's actually cases out there which, you know, a contractor, an electrical contractor, was on site for 3 days and then 4 days, 2 weeks apart, and the judge found that they didn't have frequent or extended period or exposure because they weren't on site for more than 5 consecutive days, and it wasn't frequent because it was 2 trips to finish the job. Otherwise, you know, some judges might find this, and MSHA might find that to be frequent or extended exposure because they were, you know, maybe it was a week apart, and if they hadn't had that intermittence or they hadn't had that delay, there would be 5 consecutive work days. So again, it's a sliding scale. We have to look at them both together. But if we are an operator, you know, first we should be making sure that our contractors understand this. And, you know, really most contractors that are doing substantive work should have comprehensive minor training. If they don't, we want to make sure that they are not going to be falling into that category for us. And if we believe a contractor needs it, that the contractor disagrees, you know, I encourage you to talk that one out and not just accept that the contractor says they're okay without it, because ultimately the production operator and or the contractor can be cited for the miner on site who is not adequately trained. Similarly with Part 48, we see that regular exposure means frequent exposure or extended exposure or both. So it's similar definitions as we look through that between the two. A pretty important case when it comes to jurisdiction and just kind of the bounds of where MSHA can claim jurisdiction was the Maxim rebuild case. And this, again, is a couple years old, but still relatively fresh. And it was issued by the Sixth Circuit Court of Appeals. And in that, you know, there was a time when MSHA was really trying to expand their grasp to facilities off-site. Maybe it's an off-site maintenance plant. Maybe it's an off-site truck depot. And, you know, the trucks participate in the mine process at some point or possibly do not. And, you know, the agency kept trying to creep. They kept trying to expand their reach. Oh, you guys have this shop off-site, you know, MSHA has jurisdiction there. Well, it finally came to be a question that was taken far enough along that the Sixth Circuit rendered a decision that is now controlling for the Sixth Circuit. It's persuasive to the other circuits, and it's controlling on the Federal Mine Safety and Health Review Commission. So very, very influential decision. And it held that MSHA jurisdiction only extends to such facilities and equipment if they are in or adjacent to, in essence, part of a working mine. And so in this question, it came up, did an off-site fabrication and repair facility used to make mining equipment and repair mining equipment, was it under MSHA's jurisdiction? And, you know, and what happened is this facility, this Maxim rebuild facility, was on an abandoned mine property or adjacent to it. It was in the same building as the mining offices. It was partially owned by the company, the mining company at some point in time, but the mine was no longer active. And MSHA came in there and wanted to look at and inspect it and issue citations. And so questions arose about, you know, how much of the equipment they build and repair in there was in the mining world, how much of that, you know, what percentage of it was therefore was that facility in mining. the Sixth Circuit came over and really kind of tailored this in and really cut off at the knees an old case that was a Jim Walter Resources case in which MSHA was granted the authority to go off-site facilities or off-site supply shops and then conduct inspections. So what this did was it said, if you're not on an active mine or adjacent to that active mine, MSHA doesn't have a jurisdiction to go there. If you're sharing the same property and you're part of the mining operations, yeah, they can go in there unless you're specifically carved out by the other jurisdictional arguments and analysis. But you know, it really limited kind of MSHA's push, we'll call it, an expansion into other areas. So it was a very, very good decision for the industry. And we should continue to focus on that. And if you do have questions about jurisdiction and what facilities MSHA can and cannot look at, that's certainly one that you want to check out. So is it an off-site facility, or is it on-site or adjacent to a mine? Then that's going to be, that physical proximity is now a much more controlling part of that analysis, thanks to Maxim. So, you know, what happens if we want to challenge jurisdiction? You know, first I would say you want to look at your facility. You want to determine who you think is the appropriate regulator. And you do that by conducting a review and reviewing the information that we've just talked about. You know, you contact a outside counsel or someone of that nature, you know, like myself, who can help you go through that analysis and make sure that you are looking at it correctly and weighing the right elements. And then you come to a decision: what agency should be regulating us, or why? And then you got to prepare your arguments and your analysis. Because once you go to MSHA, you need to be prepared that they are going to be of the position, or OSHA, I should say, but we'll phrase this or frame this in the sense that we're challenging MSHA jurisdiction. You're going to go in there and you're going to say, this is why you don't have jurisdiction over us. And you need to have that information laid out so that you make a persuasive argument, because they're immediately going to go look at all the reasons why they should have jurisdiction. And you want to let them know that we've considered those and we've still determined that this is the case. I always think it's better to challenge jurisdiction before you have enforcement involved. So don't wait to get inspected. If you have concerns or you have questions about what a agency or regulator should be enforcing at your site, don't wait for them to come out and assert jurisdiction. Try and head that off. Make it a proactive argument, because MSHA is a lot more likely, and OSHA is a lot more likely to try and hold on to something they already have rather than something they don't know they have or don't have. So be proactive with that. You want to talk about it. You can go to the district office is always a good place to go. Your field office, if you have a good relationship with a field office supervisor, you know, those are starting points for you. Then from there, you can go to the MSHA national office if you really need to, and the solicitors. But make sure you're prepared when you go into this. Don't just go in and say, hey, you know, hey, Nick, I don't think you guys have jurisdiction. I'd like it if you stopped. You need to know why, and you have to be able to communicate that to them. If you, again, as you said, it's always better to do that before there's enforcement or before there's an inspection, because every time you let the regulator come out and conduct an inspection without pushing back, you're in a way acquiescing to their assertion of jurisdiction over your facility. That's doubly true in their eyes if you receive a fine or violation, whether it's a citation or order from MSHA or a citation from OSHA, and then you pay that and move on. You know, the agencies will definitely try and use that against you to say, look, they've accepted it. They've said, you know, hey, we got a citation. So, you know, if you do get in the position where, hey, you don't even think about it, and you're sure you're not under MSHA until you get inspected and an inspector claims jurisdiction, don't accept the penalties. Don't pay the penalties. You know, don't pay the fines. You got to contest them immediately. You got to specifically say in your contest that I'm doing this because there's a lack of jurisdiction, because you have to set the table. If you pay fines, you're going to have that used against you. And the solicitor's office will certainly say, this is an example of them accepting our jurisdiction. So if you are challenging MSHA's jurisdiction, say they come out and they give you 5 penalties, maybe 3 of them are non-SNS, you're like, oh yeah, that guard wasn't on. I get that. That's a good citation. You really just need to contest them all, because you're fighting the ability of MSHA to issue that citation in any way, shape, or form. Because if they don't have jurisdiction, they shouldn't issue anything. Even if the guard should have been on, and even if the guard wasn't on, you still have to contest that citation because you're challenging their jurisdiction over you. So that's a quick overview of MSHA jurisdiction and OSHA jurisdiction, where the delineations lie, and some best practices if you feel the need to contest it. As always, follow us on the MSHA Defense Report, especially with the question about the COVID ETS and how that might be applying with OSHA and MSHA and application of the mine sites. We're going to post everything that we put together as a firm that's relevant to y'all up there. We also are going to keep doing our annual webinar program. So our next one is the end of October. And we'll be talking about tips and strategies for contesting citations with MSHA. So if it's something that you're looking to do or something that you already do, we're going to help you refine that. If you're new to contesting citations, maybe new to that responsibility, we'll give you some goalposts and some strategies for starting off there. As always, I appreciate everyone getting on. We try to stick to that hour for our MSHA webinars, and we're right up against it. But if there are questions, and I think we have a couple questions in there, so I'll get to those in a moment. I encourage you to send them in or to contact me directly. All my contact information is up on the screen right now. Don't hesitate to call me. Don't hesitate to shoot me an email, and we'll talk through these. Again, these jurisdiction questions, they can be very tricky because there's very few bright line rules unless your operation is specifically called out in that interagency agreement assigning jurisdiction to one agency or the other. So, I'm always happy to talk through that, and we can look at what maybe has to be analyzed for your specific operation to decide what agency we should be going through, and then we can strategize on how to go back and maybe get that reassigned if we need to. All right, we have a question, and that is asking, can corporate offices on a mine site be subject to OSHA? The person says that they understand it should be a case-by-case analysis, but again, that's going to depend. Where is it located on the mine property, and what is taking place at it? Typically, MSHA has jurisdiction over everything on the mine property unless it is specifically going to be OSHA. So if you have an office that serves as the mining institution, and serves as their office location, it's likely going to be under MSHA. But if they are the corporate headquarters for a much larger operation, and many of those are OSHA, it could be under OSHA jurisdiction at that point in time, because if it is distinct and separate from the mining operation. So it really depends what the building is used for. If there's any additional operations taking place, is it a corporate office as well as a repair shop? It is possible that you could have, though, OSHA jurisdiction over a building on mine. That is very much a possibility, depending on how it is being used, where it's located on the property, and what other businesses it oversees or operations it is overseeing. So that's certainly an option and a possibility there. That's all of our questions coming in right now. So we'll get going and let everyone log off. But thank you for your time and attention today. And again, don't hesitate to reach out to me directly if you want to continue this discussion or have any questions about anything we talked about today. So thank you, and everyone have a great rest of your Tuesday.